The honourable member for Courtenay-Alberni.
Thank you, Mr. Speaker. Again, I rise for the 30th time on behalf of the Nuu-chah-nulth on their right to catch and sell fish. A week and a half ago, Mr. Speaker, BC Supreme Court Justice Mary Humphreys found that Canada had failed to justify its infringement on the rights of the Nuu-chah-nulth people. The judge found that Canada, in large part, has not justified how it addressed or failed to address the Aboriginal right since its declaration. This means Canada has not lived up to its constitutional obligations. Canada has wrongly applied regulations and policies to the First Nations that unreasonably restrict their rights and has not fulfilled its obligation to provide allocations that allow for the exercise of the right in a viable fishery. She said, Mr. Speaker, in paragraph 1771, nevertheless, in my view, the plaintiffs have obtained a large measure of the relief they sought before Garson J. That is, the prima facie infringements she found to exist within the legislative, regulatory and policy regime have in large part not been justified. Accommodations have been offered, some appropriate, some inadequate. She identified ministerial stonewalling, Mr. Speaker. The judge found that the Minister of Fisheries stymied or stonewalled negotiations by failing to provide a negotiating mandate to those local officials. She noted that there was a lack of meaningful mandate from Ottawa and pointed out that local DFO managers, quote, attempts to move forward were stymied by the minister, end quote. And this is in paragraph 665. The following quote is typical of many in the judgment, Mr. Speaker. Quote, in paragraph 798, overall, however, Canada, through DFO, has the responsibility to represent the honour of the Crown. The lack of a mandate and Ottawa's stonewalling of suggestions for advancing the development of a right-based fishery are significant factors in the failure of the process to move forward. Ottawa failed to allow the regional staff to engage meaningfully and wholeheartedly in the negotiations, at least until the Supreme Court of Canada refused leave the second time. As the plaintiffs repeatedly pointed out, there is no evidence before the court of any engagement by Ottawa staff on this fishery other than the occasional signature on a briefing note and reference to one meeting with a ministerial assistant which was not coordinated with local managers, end quote. This has not changed, Mr. Speaker, despite 2.5 years of Liberal government and unfulfilled promises of rights recognition and a new relationship. Canada needs to change its approach to how they implement the right. And, Mr. Speaker, if the Liberals wanted to carry on the mandate of the Harper government, congratulations, because they just did that, Mr. Speaker. The ministers need to champion the term sheet with Cabinet. The one thing that the minister has done since coming into office is to appoint Joe Wild to lead a reconciliation table with the nations to develop an agreed-upon approach to implementing the right. Through the process, federal and Nuu-chah-nulth negotiators have come to a term sheet whereby they have set out a model that will allow the implementation of this right and the broader reconciliation of the nation's fishing interests with Canada. That agreed-upon approach has been stuck or stymied at the Cabinet level for many months now. Almost 2 years in a meeting with the Nuu-chah-nulth nations in Ottawa in June 2016, the three responsible ministers, Fishery, Justice, and Crown Indigenous Relations, promised action on this file for the nations. Yet the agreed-upon term sheet has been stalled at Cabinet. Will these three ministers champion the term sheet and ensure that it gets the necessary Cabinet support to fulfill the government's commitments to the Nuu-chah-nulth? Instead of trying to narrow the Aboriginal right, why doesn't the government focus on living up to its commitments and support these Indigenous fishing communities rebuild their local fishing economies and culture? The nations need real fishing opportunities that support their Aboriginal right to a commercial fishery. The piecemeal approach, like the licenses offered earlier this year, is not going to achieve that and is certainly not going to achieve true reconciliation.
The Honourable Parliament Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. A renewed nation-to-nation relationship with Indigenous people is based on recognition of rights, respect and cooperation, and partnership is a top priority for our government. The federal government remains committed to the consultation and negotiation process, supporting the implementation of the rights of the 5 Nuu-chah-nulth First Nations. In its decision in the Ahusa Justification Trial, dated April 19, 2018, the British Columbia Supreme Court clarified the nature of the scope of the right of the 5 Nuu-chah-nulth bans on the west coast of Vancouver Island as a small-scale, artisanal, local, multi-species fishery to be conducted in 9 nautical mile strip from shore using small, low-cost boats with limited technology and restricted catching power and aimed at wide participation. The decision also found that the Fisheries and Oceans Canada has taken useful steps in some fisheries to accommodate the 5 Nuu-chah-nulth First Nations rights. However, the court also noted that improvements still needs to be made. In particular, the court found that the DFO's Pacific salmon allocation policy was not justified in according priority to the recreational fishery for the 5 Nations Aboriginal commercial fishery. As an immediate step, the Minister of Fisheries and Oceans announced on the day of the decision that Fisheries and Oceans Canada is undertaking a review of the Pacific salmon allocation policy in collaboration with Indigenous groups and with all stakeholders. As well, just a few weeks ago, the Minister was pleased to offer additional licenses and quota for ground fish, salmon, and shellfish to the 5 Nations. Court decisions help inform the broader process which seeks to provide stability and predictability around the management of fisheries and ocean resources. As the Minister has stated on previous occasions, the Department is committed to reconciliation and to advancing our relationship with the 5 Nuu-chah-nulth nations to accommodate their fishing rights. In fact, it is the government's intention to continue to work with these First Nations through negotiations designed to bring clarity to the reconciliation of the First Nations Aboriginal rights. The matters that are the subject to negotiations are inherently complex. At the request of the 5 Nuu-chah-nulth First Nations, a new negotiation process was launched in March 2017 with Crown Indigenous Relations and Northern Affairs leading Canada's participation. In addition, a former Regional Director General for DFO Pacific Region was brought in to help facilitate discussions. The 5 First Nations and federal officials have completed a framework agreement that has provided a common understanding of our respective views and is assisting us in finding mutually agreeable resolutions to the outstanding issues. I can assure that this government is committed to continuing to work with the First Nations through the current consultations and negotiation process to implement the rights of the 5 Nuu-chah-nulth First Nations. Thank you, Mr. Speaker.